Hi everyone, hoping that you all are well. This is Dr. Tracy McCarthy, psychologist, attorney, and educator. We're going to be discussing the Roe v. Wade situation, also known as the Dobbs case. A number of people are really upset, or in the alternative, they are overjoyed related to the recent decision. One thing that is clear based upon this extreme upset and the being overjoyed is that many people actually haven't read the case, and so therefore many people are not clear about what the case was about, what the actual outcome was, and what the implications are. And so, contrary to popular opinion, the recent court decision did not outlaw abortion throughout the United States or in any particular state. And so what we're going to do is we're going to look at what actually took place in the court case, what was decided, why it was decided, and what the implications are. And when you see the length of the case, you'll know very clearly that some of the reactions that people had were premature because people did not have the time to actually read the court opinion prior to responding, either through Twitter or Instagram or doing videos. And so you had a lot of opinions out there without people taking the time to actually dissect this very weighty case. And so for clarity, this is not the Roe v. Wade case. This case is Dobbs versus Jackson Women's Health Organization. Okay, so this is Dobbs v. Jackson. This is coming out of the Fifth Circuit to the U.S. Supreme Court, and it was decided on June 24th of 2022. Now, it was argued back in December, but now we have the actual decision and the opinion. And so that's what we're going to be looking at. And of course, there are implications for Roe v. Wade that have grown out of this decision. And as you can see, there is significant media attention being given to this particular case. And one thing that is noted in the media is that there will perhaps be significant upheaval with respect to how the states respond to and negotiate this particular Supreme Court decision. And here already you see some of this upheaval. You have the New York Times reporting on one jurisdiction and the conflict or potential conflict between a law that has been enacted and the actual constitution for that state. And so even though you have a decision coming from the federal level, you still have to deal with these cases that will be coming at the state level, challenging some of the decisions that are going to be made. In addition to some of the legal movements and political movements, you will also note that there are social movements going on. And in one instance, you see this indication that younger men are seeking vasectomies in the wake of this Roe v. Wade ruling. Now, you may be aware of many personal opinions related to the case and political opinions related to the case. But what we're going to focus on are the key concerns that are addressed in the actual case. So we're looking at the legalities of the case. And some of the key concerns revolve around constitutional rights. That's right up there at the top. The 14th Amendment, what's known as the standard of review, and we're going to address what that is. The court also addressed the issue of Supreme Court power, state legislative power, also the issue of police power. And if you think about what's been going on over the last couple of years, many of the issues in this case in terms of constitutional rights, in terms of federal power versus state power, you see those issues have been going on over the last couple of years. And so this case in many ways is addressing some of the topics that we've been addressing over the last couple of years with respect to another health issue. And so this case also, of course, is addressing this construct of police power. And also, it does quite a review of the national state statutory history in this very lengthy opinion. And here you can see highlighted that this case is 213 pages. And so you have a lot of reacting to the case without people even looking at any part of the case. This is very similar to what happens with a number of statutes. You have these statutes that are almost 1,000 pages, and people are responding to these things when it's clear that most people have not sat down and read 1,000 pages of legislation. And so you have this going on all the time where people give personal opinions, and then you have politicians talking when they haven't even read these pieces of legislation that they are either supporting or opposing. And so this case is no different. And so again, it's 213 pages, and so it was impossible for people to be reading this entire thing on the date that it was delivered, when they were responding with all sorts of commentary, very significant commentary. And so we're going to, again, look at some of the key concerns and some of the things that were addressed throughout this case. And here you have the case header information, just in case you want to look this case up so that you can see it for yourself and read it for yourself. It's coming out of the Fifth Circuit. Now we're going to go over some key sections in any case. So if you are deconstructing a case, these are some of the things that you should look for. And this is with any court case. And so the first thing that we're going to look at is the legal issue. And that's basically the question that has been put before the court for the court to answer. And so the court is essentially saying that they have to decide what standard is going to govern state abortion regulations that undergo constitutional challenge. And so specifically, they are looking at the law for the state of Mississippi. And the question that they are trying to answer, they are grappling with, is whether the law that has been presented to them satisfies the appropriate standard. And we're going to talk about what they see the appropriate standard as being. Now, there is some question when I look at it about whether this is the appropriate standard, but they definitely make a valid case for this standard that they are upholding, essentially. Now, this ruling is growing out of a case coming out of Mississippi. And at issue is this Mississippi law known as the Mississippi Gestational Age Act. And essentially what this act is doing is it is placing limits on the extent to which someone may obtain an abortion or perform an abortion. And so Mississippi was not outlawing abortion. What Mississippi was doing was creating a boundary around the process and essentially saying that after a certain period of time, that abortions may not be performed unless there is an emergency, essentially. And so what they indicated was, except in a medical emergency or in the case of severe fetal abnormality, no one shall perform an abortion or induce an abortion if the probable gestational age is greater than 15 weeks. So 3 months and 3 weeks. And so in terms of procedural facts, you have this case prior to making it to the United States Supreme Court, being at the district court level and a summary judgment being granted in favor of the respondents. And so initially there was a determination that this 15-week restriction on abortions was violating essentially the Constitution. That was the assertion. And then you had the Fifth Circuit affirming this. However, the United States Supreme Court has determined that these prior determinations, the district court and the Fifth Circuit, that these determinations were erroneous, and we're going to look at why there's a belief that those determinations were erroneous and why they were overturned, and then how Roe v. Wade essentially got overturned in the middle of this mix. And so really what is at issue here is this standard. And so what the United States Supreme Court is saying is that the appropriate standard is what's known as the rational basis test. And so as the judicial review, they were looking at whether there was a rational basis for this statute in Mississippi. And of course, they determined that there was a rational basis. Now, there are other standards of review or judicial test. You have intermediate scrutiny and you have strict scrutiny tests. We're not going to go into all of those, but there is an argument that can be made for the need for intermediate scrutiny with respect to this situation, because there are some sex and gender issues that can be argued with respect to this particular case. And so intermediate scrutiny is something that should be considered in terms of looking at the facts in this case. However, the court is agreeing with Mississippi that the rational basis test is the appropriate standard. And what they're basically saying is that there is a rational connection between the state's statutes and the goals, of the state. And so they are saying that, this is in keeping with the government's interest. This is in keeping with the function of the government. And it's substantially related. What they did in terms of this 15-week rule is they made a determination that was substantially related to that interest. And so they've even gone beyond what would be considered the rational basis test. And so this is very important to keep in mind, because this is what this is really all about. Whether Mississippi was operating in a way that would allow them to pass this rational basis test. And according to the Supreme Court, they did that. And so, of course, the Supreme Court is also looking at this question of whether abortion is a constitutional right. And so, of course, in the overturning of Roe v. Wade, the court determined that abortion is not a constitutional right. It is not clarified in the Constitution. It's not written in the Constitution anywhere. And so, therefore, it's up for examination in terms of where this jurisdiction actually exists. Is this something that goes to the state level or is reserved to the people? And so that's what they basically determined, that it's not a constitutional right, and that it is something that is reserved to the state or the people. Now, the court is very clear in its explanations. What they indicate here is, under our precedents, rational basis review is the appropriate standard for such challenges, And as we have explained, procuring an abortion is not a fundamental constitutional right because such a right has no basis in the Constitution's text or in our nation's history. And they do a lengthy examination of early statutes related to abortion coming out of the 1800s. And so those are actually included in this 213 page opinion. And so you get a sense of the position of the various states from the earlier times in the country's history. And so again, they are not overturning Roe v. Wade in a way that then makes abortion illegal. What they are essentially saying is that this does not belong in the lap of the Supreme Court. It belongs in the lap of the states. And so what they indicate here is the critical question is whether the Constitution properly understood confers a right to obtain an abortion. They refer back to the Casey case and indicate that Casey's controlling opinion skipped over that question and reaffirmed Roe solely on the basis of stare decisis. And so this was a concern for the court. And so the court is indicating that in the Casey decision, they did not appropriately analyze the case and they did not appropriately deal with the Roe v. Wade issues. And here you see the court disagreeing with prior assertions about this constitutional right based upon privacy rights and liberty rights, the Equal Protection Clause. The court is essentially saying that those assertions don't pass muster with this particular court. And so they do not see abortion as a constitutional right based upon liberty or privacy. Again, they are not saying that abortion is illegal. They are simply saying that the abortion issue is something that should be addressed at the level of the people or the state. And here you see the court sort of waiving jurisdiction over this issue. And so they indicate here it follows that the states may regulate abortion for legitimate reasons. Again, they are going back to that rational basis test. And so they also indicated when such regulations are challenged under the Constitution, the courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. And so, in other words, the courts cannot usurp the authority of the legislative bodies by inserting their economic and social beliefs. And so they can't just overturn things based upon this. And what they are saying is that, again, this issue does not belong in the lap of the United States Supreme Court. It's something that is a state issue. And so another thing that the court examined was whether the right to obtain an abortion is rooted in the nation's history and tradition, and whether it is an essential component of ordered liberty. And so what the court determined was that the right to abortion is not deeply rooted in the nation's history. And remember, there's an entire section where they delineate these various statutory authorities historically for the various states related to abortion and the outlawing of abortion. And so here the court also addresses the deficiencies that it saw in the Casey treatment of the Roe v. Wade case. And so they did not see the Casey court as appropriately addressing Roe v. Wade in terms of the analysis. They did not see the Casey court appropriately addressing what this court saw as deficiencies in the reasoning of the court for Roe v. Wade. And so therefore, this court addressed what it saw as some of those deficiencies. You know what's really interesting is the fact that this case is tied to, as we've noted, some of the dynamics that have been going on recently and that probably will be going on in the near and distant future with respect to bodily autonomy. And so this is not an issue that's going to be going away anytime soon. And what's also interesting is that those individuals who are in support of the ruling and those individuals who believe that abortion is now illegal, those are some of the same individuals in terms of their political beliefs, in terms of some of their beliefs about bodily autonomy. Those are individuals, by and large, that believe in all of this bodily sovereignty. And so it's very interesting that when the issue is one thing, there's a belief in this bodily autonomy. But if you flip the issue, then there's a belief that bodily autonomy is not a right. And so it will be interesting to see how this all works itself out, because again, the issues that we've been dealing with over the last couple of years have dealt with this battle over federal power versus state power, this police powers issue, and we've talked about that before. And this addresses some of the same stuff, essentially. And so those individuals who did not like putting on masks, for instance, this is actually tied to some of those issues that were presented with respect to some of the restrictions that you saw that the states were imposing. And in some instances where the federal government was usurping the authority of the states based upon the Commerce Clause. And so it's interesting that interstate commerce has not been significantly applied to this particular situation, because based upon what's been going on the last couple of years, you can just about apply interstate commerce to anything, and you definitely can apply it to this particular type of case. And here the court goes on to look at that history of statutory authority with respect to abortion. And so they are essentially saying that until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. And so they're basically saying that in terms of the Constitution, they can't find anything constitutionally that gives this right. And so again, when things are not enumerated, they are reserved to the states and the people. And so they also indicate until a few years before Roe, no federal or state court had recognized such a constitutional right. And this is one of those examples in that long list of examples that they have in the case related to the laws of the various states back in the 1800s. And so you see Ohio 1834, be it enacted by the General Assembly of the state of Ohio that any physician or other person who shall willfully administer to any pregnant woman any medicine, drug, substance, or thing, whatever, they will be guilty of a crime, essentially. And so you see this repeatedly in terms of the laws of the various states. And so the court does lay this out very well so that you can see the national history, at least for the 1800s, with respect to this issue. And so, again, in contrast to what's being presented in the dissenting opinion, you see this history of this treatment of abortion as something that is illegal. And so it's definitely not treated historically as a constitutional right. The court also touches on some earlier cases, such as the Furman case and also the Cruzan case. And what the court is saying here, very specifically, they are reiterating the Constitution does not grant the 9 unelected members of this court to unilaterally rewrite the Constitution so that they would be creating new rights or liberties based upon their own moral or policy views. So again, they are basically sort of washing their hands of this entire issue and putting it back in the lap of the lower courts. And so you can see the rationale for the holding that we are looking at now. And the holding is basically the decision. This is the answer to that question, that issue that was presented. And so the court's answer to the question is that the Constitution does not confer a right to abortion. The Roe case and the Casey case are overruled, and the authority to regulate abortion is returned to the people and to their elected representatives. And so the court is basically saying this is not ours. And they are saying this based upon the Constitution not enumerating this right to an abortion, and also there being a historical legislative pattern that is in contravention of this idea of a constitutional right to abortion. And so again, they are not outlawing abortion, and many people believe that that is what has taken place. And so you hear these protests that are suggesting a belief that abortion has been outlawed throughout the land. You also have some people who are overjoyed again because they believe that abortion has been outlawed. But basically what you see is a return to the states, and you might see some states enacting things like Mississippi again. You may see some states becoming even stricter, but you may see the flip side of that, where states may become even more lenient to allow increased access. And so for this reason, all of these reasons, it's important when you hear about these major cases coming down the pike that you actually become a bit more familiar with these cases before making determinations and assertions about what the case is talking about, and also so that you can better understand the logic of politicians when they are presenting opinions about a court case, so that you will know whether the opinion that is being presented is consistent with what the case is really about. And so you have a large number of individuals who are responding to this case inconsistent with the reality of the case. Again, many people are asserting that it's all about outlawing abortion, and that is not what this case is about. Even the original case was not about outlawing all abortion. What that original issue was about was the timing. So there was a time limit on when individuals could and could not obtain an abortion. And so abortion was legal. There was just a limit on when an individual could procure an abortion, under what circumstances. And then even beyond that 15-week limit, you still had abortions being allowed in the event of an emergency. So if there was a health issue, you still had abortions being allowed beyond that 15-week time period. And so again, this is one of those situations where it's very possible that people perhaps should have considered leaving well enough alone, because now you have this major upheaval with this overturning of Roe v. Wade, simply because of pushing up against this restriction, which, according to the United States Supreme Court, passed the rational basis test. Now, you're also encouraged to look at the dissenting opinion, because that's the part of the case that's going to help you to see the other side of the argument, the other side of the analysis. And so you can see the individuals who dissented, and then you can see their rationale for the dissent. One good thing about the dissenting opinion, in any case, is that it brings forward the caveats. It brings forward the nuance that we need to always consider when we are looking at cases, because there is not usually a cut and dry analysis that can be applied to every single situation. And so when you think about this situation with abortion, not every situation is going to be the same. And so it's really not possible or helpful to have these blanket determinations that apply to every single person and every situation. For instance, you don't always have a pregnant woman in the situation. Sometimes you have an individual who is pregnant that happens to be younger than an adult woman. And so there are a number of things to consider as we wrap this up. But that's why it's also important to read the dissenting opinions, so that you can get a better sense of the flip side of the argument or the consideration. Another important consideration that comes out of the dissenting opinion is the consideration related to the balancing of rights. And so you have some individuals who believe that all of the rights of the pregnant woman should basically be ignored. And then you have some individuals who believe that the pregnant woman should have all rights, and other rights should be ignored. And so what the dissenting opinion is asserting is that we need to always be mindful, as with other legal situations, of the balancing of rights. And so that's something that we need to take into consideration, whether we're looking at this particular issue or whether we are looking at other issues, because we do, over the last couple of years, have a history of these determinations being made based upon this balancing of rights, and in some instances usurping the rights of individuals in favor of these perceived rights of other individuals. And so you see where this Dobbs case, this Roe v. Wade issue, is tied to some of the health determinations that have been made recently and that continue to be made. So we still have a lot of court cases going on addressing a number of these issues. But again, what the dissenting opinion is asserting is that we need to be mindful of the balancing of the rights, and not simply walking all over the rights of the pregnant woman. Remember, knowledge is power. Take care. See you soon.